opportunity in the poor city. No, it is not fulfilled. They have a fundamental right under Horton, under Sheff, to the enjoyment of an equal educational opportunity. And I take it that's what this case is going to be about, ECS formula and all, down at the trial court. That the way the state funds its education does not give those students in certain urban areas or other areas an equal educational opportunity and the right to enjoy that, the right to free and public schools, as a matter of equality, not as a matter just of quality.
Doesn't the concept of equality connote some substantive context, or content rather?
Well, to measure equality, you need to have some qualitative measures, but for purposes of comparing, not for purposes of saying this is the floor. I don't believe, and other courts have determined that there's not a role for the court in simply deciding what the quality should be as a floor. That is a non-justiciable question. Under our Constitution, with no text to go by, we don't have words like thorough and efficient, high quality.
What does equal educational opportunity mean then?
Well, that is something that needs to be fleshed out. Horton 3 said that. There may be innumerable factors that go into that, including what the children come to school with.
But if it doesn't include a substantive component, what does it mean?
I think what substantive, I hope I'm answering your question correctly, to determine what substantive components to compare.
Yes.
I think those questions will need to be asked in an equal protection proceeding.
Doesn't that suggest that there is a substantive component that's constitutionally required?
I don't believe it does, because I think those substantive components can change. And the question always is, as we raise the substantive component, the opportunities, the resources, the abilities for kids to achieve, are we doing it equally with other children? That's the Horton challenge. And that is a history that we have that many other states do not.
So without a qualitative, an implied qualitative factor, everybody's entitled to an equally inadequate education, would be the way you'd interpret the Constitution.
Your Honor, in the worst of all worlds, that could be the situation. If all children were doomed to an equally inadequate education. In our democracy, I highly doubt that would happen. Education is perhaps the paradigmatic democratic issue being argued at every level, local, state,
You're talking about
federal.
a public policy component now. You said a moment ago, you referred to the text, and if the text didn't provide such and such, but isn't that what the Geisler analysis is about, to enable the court to determine what a constitutional provision means? Because they're traditionally in very broad general language.
Well, they're not as broad, they're not in general language. Let me put it this way. There are more adjectives and there are more guidance given to courts in other states, such as thorough and efficient, high quality, adequate, inviting the court to measure those. We don't have that in our state.
But we're not the only state that doesn't have them.
We're not the only state.
Brings me to the preliminary issue that I asked other counsel about. This is the most preliminary gatekeeping stage, the motion to strike. Now, normally, in most cases, I suppose the trial court is more concerned with the factual allegations, because you're more often than not dealing with a rather traditional cause of action, negligence, torts, some contract, something like that. A constitutional claim is different.
Correct.
One could almost say that merely to allege a violation of a constitutional provision that has some relation to its language is enough. But we don't say that.
Correct.
We say we have some factors to look to. In contract or torts, you look to elements. Well, are the basic elements there? We know what they are usually. When you're doing a constitutional analysis in the state constitution, you don't have that set of elements that you usually have, but you do have the Geisler factors. So my question is, why doesn't the trial court do a similar kind of analysis by looking in that gatekeeping way to the Geisler factors and determine whether the elements are satisfied in some preliminary way. And for example, if we have 4 other states with similar constitutional provisions, well, that's a ground right there, a possibility to interpret our Constitution that way. If we have some statements by our Supreme Court, there's another factor. Why isn't it enough if on this basic first look at Geisler, rather than the merits review the trial court did, it's determined whether it passes this first bar? Because that's what the trial court should have been concerned with, the first bar, not an ultimate decision on the merits.
Well, the ultimate decision on the merits is simply not that they didn't prove the merits of their factual claims, but that, like any classic motion to strike, there is a failure to state a judicially cognizable claim. I still believe, Your Honor, that the gatekeeping function is properly done by looking at all of the legal questions, all of the legal inputs that make up the Geisler analysis, which, by the way, the Geisler analysis is not a magic formula that has sort of factual elements to it. It is what this court has announced as criteria that inform the legal question of whether there is a cognizable state constitutional right. And I guess looking at it from the trial court's perspective, from the trial judge's perspective, what factual development would we need to determine whether there is a right? The plaintiffs point to historical analysis and social and economic factors. Well, historical analysis is not, for Geisler purposes, or perhaps in most instances, unless there were a factual dispute over the facts of the case, are not susceptible to a swearing contest. Whether historians like it or not, and they may be horrified by it, judges and lawyers use the history to inform the legal analysis, not as a matter of a historian getting on the stand and saying, this is what happened in 1965 or in 1818. That would, of course, be hearsay. He would, of course, have no firsthand knowledge about it. But we use the factual evidence, the courts say in quotes, to inform what we believe was the intent of the provision.
But is it the function of the trial court at that stage to decide what of that evidence to believe and what to reject, or merely to say it's there and another trial court may look at this and the other factors and decide whether it meets the standard for a constitutional right?
I fundamentally disagree, Your Honor, that in a civil case where the question is a legal one, that really what the judge would be doing in that case is leaving it to a higher court to determine what the historical or the textual or what other. There are really no triable facts about that make up the Geisler analysis. Even as to economic and social factors, this court's cases have used them sort of in the Brandeis brief type way, where they look at economic factors, almost in the same way Your Honors do statutory construction.
Yes, but usually a trial court does it after taking some evidence and giving the parties a chance to have some input. The trial court created all the factors itself.
I disagree, Your Honor.
And then decided which to believe and which not to believe.
I disagree. I don't believe that constitutional adjudication under the Geisler analysis is any different or much different from statutory construction of what a statute means. If somebody alleges this is what a statute means, you should look at the legislative history, you should look at the purpose of the statute, you should look at the bizarre results that might result. I don't believe the court takes evidence on that. I think the court would then tee up the question and say, yes, you've convinced me as a matter of statutory construction, and I believe that Geisler, the analysis of Geisler is similarly a legal question. Now, most often, these cases come to the court after an evidentiary record because most often they come up in the criminal context. So there has been a trial of some sort or a suppression hearing. So that's why the plaintiffs are able to say, most of the time there's a factual record. There's no preliminary kick-out of there aren't many civil cases, but I don't see Geisler, and I don't think anything in Geisler or its progeny indicate that a claimed constitutional right, state constitutional right or otherwise, is not susceptible to a failure to state a claim